Hello, good afternoon.
Hello, Emmanuel.
Yes, this is Legal Angle with Emmanuel Olawale. I have with me Micheal Cassone. Welcome to the show, Michael.
Thank you, Emmanuel. It's great to be here. Thanks for having me.
Yes, can you please tell the audience about yourself?
Absolutely. My name is Micheal Cassone. I am running and I am the current candidate for the Franklin County Court of Common Pleas General Division. I am not the only candidate, but I am a candidate that you will see on your ballot if you go to early vote, which started this past Tuesday, if you happen to vote absentee and or if you show up to vote in person on November 3rd. I will be a listed candidate. I am running for judge. I have been an attorney for over 15 years in and around Franklin County and all over the state. My practice has been primarily focused on the civil arena with attention to housing issues, both from a residential and commercial standpoint. Throughout my time as an attorney and in and around the courtroom, I have litigated no less than 200,000 cases, with predominantly in Franklin County, but all over the state of Ohio as well, up through the appellate level, and even briefing some cases with respect to the Supreme Court. So I am experienced. I deal across the aisle and deal a lot with individuals that are represented by counsel, and I deal a lot with individuals that are unrepresented. So it's not unlike me on a daily basis to talk with someone either with them through an attorney or just talk to them who is a party to a case and who is quite frankly scared to be in a courtroom because they're not used to being there. And oftentimes my clients and the individuals on the other side all walk away with a sense that their wishes were respected and their needs were addressed and so on and so forth. So I did my undergrad. I grew up right outside of Columbus in Fairfield County. I did my undergraduate at Ohio Wesleyan University. And then right out of there, I went into Capital Law School, where I was a full-time day student and then took and passed the bar the first time out. My wife is a domestic court magistrate in Franklin County, and she and I together have five beautiful children. We have a 7-year-old boy, a 5-year-old boy, and we have 2-year-old triplets that are a boy and two girls. Although I say 2-year-old, hold on to it as much as I can because they turn 3 next Wednesday. So they're two
Wow.
until they're not, as far as I'm concerned. um, so
Congratulations.
Yes,
Yes, no,
thank
that's
you. Yeah, it has been a wild, wild ride, and I look forward to. It's been my lifelong goal to serve the public from the judiciary, and I look forward to and thank you and appreciate your support and vote.
oh, thank you. Now let's talk about housing. I know you've been a real estate attorney for quite a while, maybe about 15 years now. Do you represent only landlords, or do you represent both landlords and tenants, or do you represent only tenants?
I represent both landlords and tenants. I can say that the majority of my work over the years has been from the landlord side, but I recently went out on my own and opened up my own law firm as of April of 2019, and I started taking on a lot more tenant cases. Not to say that I didn't have any before, but I took on a lot more tenant cases this past 18 months or so. So yeah, a little bit of mostly a mix.
Okay. Okay. And you said earlier that you've litigated over 200,000 landlord-tenant cases. With that calculation, to me, that's about 13,333 cases a year and about 1,111 cases a month. How were you able to handle this humongous number of litigation?
There are a lot of evictions in Franklin County and around the state of Ohio. There are just last year alone, there in 2019, there were over 18,000 eviction actions filed in Franklin County, by far the largest county in the state of Ohio with respect to eviction filings. Now, please don't let yourself and the public get confused. That doesn't mean there were over 18,000 evicted people, because there weren't. The greater majority of them were dismissed and worked out well in advance of the hearing, either by way of the tenants electing to move voluntarily or by coming to an agreement with their landlord and paying it off and getting current in their lease. The other majority of them whereas you may see an eviction judgment on someone's record, it never goes to, or I don't want to say never, but a majority don't go to a set out because the tenants either leave voluntarily or, quite frankly, they get it worked out. Landlords, despite the high numbers, don't let that scare individuals in Franklin County. Landlords want to work with their tenants. By and large, if the landlord is forced to file an eviction, that is the very last resort they want to take, because now they're left with a bill from their attorney, an unpaid bill from their tenant, and an empty apartment that they have to try to rehab, market, and get someone else in there. All three of those factors don't make for a good business model for anybody wishing to invest in real estate from a rental perspective.
Thank you. And while you are also practicing law, you also worked as a law professor. What was that like?
Yeah, so I had the honor and the pleasure of being invited in to teach real estate law to the Capital University paralegal program. I was an adjunct professor there. Since my wife had the triplets in 2017, I've taken a break from teaching at Capital, although I could go back at any time. I would love to do that, and I greatly look forward to the time when my kids have a little bit more independence, and I can go back to teach. And then as soon as I just said that, I realized that no, I don't look forward to that, because I don't want to look forward to my kids growing up, because as soon as I know it, they're going to be asking for the keys. So the reality is I just got to live in the moment and day to day. And right now I'm loving being a very, very busy father and a candidate for your judge in Franklin County.
I can only imagine. No. Yeah. Now let's talk about the housing issues. What are those housing issues that people are going through right now as a result of the pandemic?
As we could imagine, Emmanuel, there are so many tenants that are faced with a downsize in either their hours of employment, their employment altogether, or their pay within their prospective field. And that in turn has affected directly and indirectly their housing, causing them to fall behind with their landlord and thus subject to an eviction. So in Franklin County, since the pandemic hit, and the Franklin County changed its rules via an administrative order on March 17th of 2020, they were seeing between 200 to 250 cases a day. That got bumped down to 100 cases per day on the docket, give or take. There might be some that get onto the docket because of a continuance, or there might be some dismissals leading up to and right before the hearing. But for the most part, it's an average of 100 a day. The evictions in Franklin County are now down at the Columbus Convention Center. They are not at the courthouse, with the idea behind that and the public policy is to thin the number of people actually in the courthouse and put them in an environment that is more spread out. They did that with both the eviction docket as well as the traffic docket in municipal court. That lease with the Columbus Convention Center ran through August 31st and was extended through December 31st. So right now, all housing matters or eviction matters are being heard and determined by magistrates down at the Columbus Convention Center. And they're still doing it and rotating it on 100 per day docket. So if you average out 22 business days a month, the court is still seeing over 2,000 evictions a month alone in Franklin County, and that number is staggering. Now, understand, however, getting back to what I said earlier, that doesn't mean over 2,000 people are getting evicted, because there are a lot of great programs out there for tenants right now to seek help and get assistance, either be PRC, Columbus Coalition for Homeless, Impact, a number of other veterans affairs, things of that nature. So what happens right now is that although an eviction hearing is scheduled, the court wants to know if the tenant wants to stay. And if in fact, if the tenant wants to stay, and these are for non-payment cases, we'll get to other cases if you want to talk about those with respect to criminal activity or disturbing the quiet peaceful enjoyment or pets or anything like that. But for non-payment cases, the court will oftentimes continue the case a week so the tenant can get in line, so to speak, or get their application submitted so that way they can get qualified and hopefully approved with some assistance. That way they can get their landlord paid up and they can get current and remain a tenant at that particular property. In September 1 of this year, The Center for Disease Control came out with an order that went into effect September 4th. And it was an order declaring that if a tenant who was facing an eviction presented a CDC declaration, and there's specific language in that declaration that the tenant must provide the landlord, then the court has the discretion to stay or put on hold an eviction case all the way until January 1 or after. So that can have far-reaching consequences for not only the tenant, but as well as the landlord. So right now, everything that's happening is the tenants are being pushed into, either voluntarily or involuntarily, quite frankly, into go get assistance. We don't want you to be homeless. So right now, the evictions that are happening down at the courthouse are in large part by people who just don't show up. And even then, some of those people will then get red tags put on their door and then rush to the court to say, oh my God, what do I do? And even then the court will go out of their way to try to help that tenant maintain their housing so as to not risk the spread of COVID by displacing a family, and or allow the tenant to remain there and paid up, and the landlord to, quite frankly, meet their bills on the other end with their lender.
Okay. Oh, thank you. There have been reports in the news where where the report about federal government passing laws or orders that there shouldn't be eviction for a time called moratorium. So people out there asking the question, how does that apply to me if I'm in a private residential lease?
So prior to the CDC, there was a CARES Act eviction moratorium that went into effect until July 25th of this year. And that was if you were a covered dwelling, the landlord was prohibited from even filing the eviction against you. And in order for it to be a covered dwelling, there were many factors, but to boil it down, it basically meant that if you received government assistance, either the landlord for its property or the tenant for its unit, then you could be considered under the CARES Act and have no eviction filed against you. That moratorium has since passed. And now what's in effect is a CDC declaration, which creates an affirmative defense for a tenant that is, once the is filed, they can present this declaration to show that they've exhausted all of their rights and remedies to get third-party assistance. They would otherwise become homeless. They've tried to make partial payments, and therefore they need some help. And the court could exercise their discretion to do that. So it's a misnomer for people out there to think that the current state of affairs is that there's an eviction moratorium. That is not true. Absolutely not. And in fact, for the clients of land that are landlords of mine, I counsel them that the only way your tenant is going to be eligible in some circumstances for assistance is if they have an eviction filed against them and if they show up to court. Because, for example, Impact, great program, it has a lot, millions of dollars in grant money giving out to help tenants. Right now, Impact is so busy that you can no longer apply online if you're given a 3-day notice and you fall behind in your rent. So prematurely, you think, wow, I'm going to go get some help so I can avoid an eviction. Unfortunately, they can't do that. I've had tenants and landlords come to me and say, my tenant went down to apply for Impact. Their court date's next week, and Impact turned them down. So, well, Impact didn't turn them down. Impact told them, we have 50 people who have hearings today that we have to address. Please come back on your court date, and we will then process your application. And so, unfortunately, there's no moratorium. There is status quo with eviction filings, but there are programs out there to help you. And this CDC declaration is the very, very last resort for the court and the tenant if, in fact, they're turned down because they don't qualify for assistance and now they don't want to be homeless. What people also need to realize, Emmanuel, with this CDC declaration is if God forbid, they aren't able to receive assistance today, and their case is stayed until January, then come January, the CDC order says that the landlord can demand payment in full for all the past months. So you could imagine the potential crisis that we have on our hands in Franklin County for those people that either who got assistance now and they don't provide assistance again, and so they might be subject to an eviction again later in November or December, or they did get their case stayed and now all of a sudden it's 10 below out and they're faced with possible homelessness because they can't pay, and they can't pay it in full, and the landlord isn't forced to do a payment plan with them.
Thank you. I see you've mentioned a lot of help or assistance that are out there for tenants. Is there anything out there for landlords who have tenants who are behind?
There isn't, that I'm aware of, programs out there that provide landlord money for tenants. There is, of course, you can, a landlord, and I've done it many a times for a client, contact their lender to put their loan in forbearance because their particular tenant or investment property isn't receiving its income, and the tenant has availed themselves of certain protections, and thus so it's a recipe for failure, and it doesn't help the lender to foreclose right now because they're not going to get their money in the free market on that. So yes, a lot of lenders are agreeing to enter into a forbearance with their owners so as to circumvent the potential pitfall of not receiving their mortgage payment.
Oh, thank you. And what protections do tenants have under the law to prevent wrongful evictions?
The Ohio Revised Code, Ohio Landlord Tenant Act, specifically Chapter 5321, provides remedies to a tenant who feel that they have been wrongfully evicted by their landlord, or retaliatory evicted by their landlord, or constructively evicted by their landlord. An example of that would be if the landlord just decides to turn off the utilities to force that tenant out. That would be called a constructive eviction. And the law affords the tenants those remedies in the event that that should happen to them. And I would tell any tenant who came in for my counsel to say, keep track of all your receipts, all your written correspondence with your landlord, because to the extent you ever need to show that you were damaged as a result of the landlord's acts, you have ample evidence to show it in court by way of receipts, to show actual damages, let alone any penalties that the court may be able to impose under the statute, which includes but isn't limited to attorney's fees.
Thank you. There's this common issue after a tenant has moved out of maybe a landlord not returning the security deposit. What remedy do you have as a tenant if your landlord refuses to, if your landlord doesn't want to give you back your security deposit and you know that you've taken care of the place, you left it in a very good condition, it's all well cleaned out. What remedy do you have? Apart
That's a great
from
question.
paying an attorney, because sometimes the cost of paying an attorney equals the deposit or even more.
Absolutely. That's a great question. And so for individuals who feel that their security deposit was wrongfully withheld, they do have remedies under the statute. In order to avail themselves of those remedies, they have to give their landlord a forwarding address. Once they give their landlord a forwarding address, the landlord then has 30 days to either refund all of their security deposit. And if they do not refund all of their security deposit, they have to give a breakdown of what part they did not return and what part they withheld from the tenant. The tenant thereafter, if they feel that the landlord wrongfully withheld any part or all of their security deposit, may sue the landlord. And if the landlord is held liable for wrongfully withholding all or a part of the deposit, then the statute is pretty draconian. It states that the tenant is not only entitled to the amount that is wrongfully withheld, but also an amount equal to that amount that is wrongfully withheld. So that's called double damages, and mandatory attorney's fees. So the tenant should not be penalized for having to get legal counsel in order to get their security deposit back.
Yeah, thank you. Now, let's talk about your candidacy. You're running for judge. What prompted you to run for office, especially in the middle of a pandemic? You just had a triplet, and your wife is already a magistrate. That's a lot of work.
Well,
What
we were
prompted you?
we were so bored at home. No, I'm kidding. I was presented with an opportunity to run against my opponent, who is a very good judge. You won't hear me say anything bad about my opponent. But I was presented with an opportunity, and if there's one thing true in politics is never pass up an opportunity because it may never come by you again. And so when presented with this opportunity, I thought, well, I spoke very heavily and sought counsel from my better half, my wife, who said, and at that point in time, there was no pandemic, there was no COVID on the horizon. We didn't know that. And so we thought, yes, we can make this happen. In fact, we could not use, that's a bad word, but we could uh, promote the triplets, promote the candidacy by and through the triplets. What an eye turner it will be at parades to see you walk out there with triplets walking beside you. It doesn't happen very often. So we certainly discussed that, and we were very blessed, and we took advantage of the opportunity to run, because, as I indicated before, it's been my lifelong goal to serve the public, and what better way to do it through my profession by way of the judiciary.
Thank you. And if you were to get elected, what kind of cases will you be handling?
So a judge in the Court of Common Pleas General Division hears criminal cases, felony 1, felony 2, I believe, and maybe felony 3. I'll touch on that in a second. And any civil case over and above $15,000. They also have administrative review. So, for example, if you have a case within the Ohio Civil Rights Commission and you are unsuccessful and you want to appeal that administrative decision, you would appeal that to the Court of Common Pleas, who then your next level of appeal would be the appellate court. So the Court of Common Pleas, it is an administrative review board, if you will. And within that, having such an extensive over 15-year practice in civil court, I have had some criminal cases, but that is where I will enter into the bench from the criminal perspective and openly walk down the hallway to my colleagues with respect to any criminal cases in me. I do have a mindset with respect to how I'll conduct trials and handle issues that, when guided by the law with respect to witnesses. But that is certainly something that I will immerse myself over and above in order to properly serve the public. And you're not going to have any judge going into and seeking out the judiciary isn't going to come having a wide range of experience 100%. So I want to caution the viewer, don't be put off by the fact that I'm 95% civil versus 5% criminal experience and say, oh, well, he's not qualified. Because there's, for one of me that is that, there is an individual that is 95% criminal and 5% civil, because they've been a criminal defense attorney all their life. So it's the temperament, it's the passion, it's the commitment to doing the job and serving the public that you will get if you elect me and vote for me.
Thank you. And you said your opponent is a very good judge. I believe that it's an incumbent right now. So if
Yes.
you are considering that he is a good judge, why should people vote for you instead of him? Why, meaning, because if you get elected, that means that they are removing a good judge. So
That's
why
a great
should they
point.
do that?
Well, this individual, my opponent has served both in the municipal court and then now in the common pleas court. And what I would bring to the bench is a fresh perspective and a unique perspective of having had so many cases litigated and dealing with individuals represented or individuals that have not been represented, so as to say that I'm able to reach across the aisle both ways to make people feel like their voice is heard in my courtroom. And for all the years that my opponent's been on the bench, he would be a great asset back into the private sector or perhaps even back into the public sector. And he'd be a great asset to our community.
I've never heard anyone answer that question like that. Okay. So what makes you better or unique or different from your opponent? Why should people pick you over him?
My qualifications would make for a great judge over either my opponent or anyone else I'd be facing, because of my extensive experience of dealing with individuals on a represented basis and or a pro se or unrepresented basis. Having come from private practice, I understand and respect the idea of carrying a large caseload, moving that caseload through to completion, while at the same time having respect and making sure everybody's voice is heard.
Thank you. And what do you want people to keep in mind when they go to the polls so that they wouldn't forget who Micheal Cassone is?
First and foremost, I want you to remember that when it comes, I want you to think of community, commitment, Cassone. If there's one thing that is true, I am all for the community. I am committed to my profession and the community, and I bring forth to the bench a family oriented, tough yet trustworthy approach to the judiciary.
Oh, thank you very much, Michael, for coming on Legal Angle with Emmanuel Olawale. Hopefully, we
Thank
can get together sometimes in the future and have more conversations about the law.
That would be great. Thank you so much, Emmanuel, and thank you everyone for watching. And I appreciate your support and your vote.
Thank you. This is Ida on Legal Angle with Emmanuel Olawale. Until next time, thank you and stay safe.